welcome everyone here and being live streamed. Just some brief notices. Welcome everyone. Thank you for coming here. The SA Prize winning presentation is a really important part of our calendar. We're very delighted to have two excellent presenters here this evening to the start of their grueling road tour. They're kicking off in Christchurch with some suitably dramatic weather to help them on their way before they go to our nation's glorious capital and whatever that town up north is called. It is so this is our the first of the evenings, and tonight is the live stream. Just some brief notices for upcoming events. I have to do this or Melanie will skin me. Next month we have Lord Justice Coulson visiting and presenting two lectures. The first is in Auckland on the 9th of September, followed by Wellington on the 16th. We'll have more information out soon, and if there will be a live stream. We haven't yet confirmed which of those two venues will have a live stream. And so now we get to the SA Prize winners. We will have Erica presenting first and then Oscar. And it is therefore with great pleasure, probably not a drum roll, that I introduce Erica Dysart, who won our second SA Prize winner for her essay, Judge, Jury and Executioner, Extending Self-Certification Abilities to Trusted Building Practitioners, a very topical subject, particularly given the initiatives that are being explored at present, announceables that are being explored at present with legislation to hopefully follow. The judge's citation reads as follows. This is a live issue with the recent announcement by the Honourable Chris Pink, Minister for Building and Construction. Those members with sufficient grey hair will be nervously watching how these initiatives will be implemented. Accordingly, or no hair actually, accordingly this paper is timely, it's well researched, informative and thought-provoking, having considered not only New Zealand, but also the landscape in Australia and the United Kingdom. Erica is a transactional construction and commercial property lawyer at Greenwood Roche, working across a broad range of construction engineering, infrastructure and real estate development projects. She has a keen interest in the relationship between government policy and the construction landscape. Please join me in welcoming Erica to present her essay. There is a clicker there which does work. There is a don't panic. There is a blank screen between each of the presentations at the beginning.
Okay, cool. Thank you. Oh, that's me. Okay. Tēnā koutou, ko Erica tōku ingoa. Thank you, Jonathan, for the kind introduction and the lovely words. Thank you to SCR for putting on this event, Duncan Cotterill for hosting it, and thanks for everyone for showing up. As Jonathan said, I'm a transactional lawyer, and moments like this make me really, really glad that I am not a litigation lawyer. My essay discusses the government's proposal to extend self-certification abilities to trusted building practitioners. From reports of bloated consenting times, the current consenting framework, guidance from the UK and Australia, and practical steps forward. Going into the essay competition, I was really interested in the raft of building reform solutions being pitched by the government. And if I'm being honest, I was really sceptical about the ability to strike a balance between ensuring cost and time efficiency and quality control. I'm sure we've all heard the horror stories of how bloated the wait time is for construction projects going through the consenting framework. The consensus is that there are excessive inspections across all sorts of construction projects, especially basic homes, with a single-storey basic home potentially undergoing 10 or more separate inspections. Building Officials Institute of New Zealand says building consents have become onerous to the point of being encyclopedic in the amount of information and level of detail required. Some builders report having to book inspections up to 2 weeks in advance due to a lack of available inspectors. This results in misaligned schedules where inspections are conducted before work is complete, causing failures and technicalities. Industry feedback reveals that although applications must be processed within 20 working days, in practice they often take significantly longer, leading to frustrating and costly delays for builders. Latitude Homes Managing Director Mark Hunter said that while the statutory timeframe for consents to be completed was 20 days. Latitude homes waited on average between 8 to 12 weeks for approval because councils frequently ask for more information at the last minute, known as a request for information. These RFIs stop the clock on the 20-day consent process and resume once the information is received. In 2024, new data showed 2/3 of building consent applications required RFIs, adding an average of 12 extra days to consent processing times. For the fellow Aucklanders in the room, or that place up north, Auckland is singled out as having a notoriously complex and inconsistent consent process, with even simple projects facing long delays and high fees, creating significant unpredictability for developers and architects. So self-certification refers to the ability of building practitioners to certify that their own work complies with the building code of the relevant jurisdiction. This can shift responsibility and liability away from building consent authorities and onto building practitioners. Ultimately, self-certification is a way to regulate the output quality of a building works design or installation. This concept is divorced from the concept of occupational regulation, which concerns one's ability to enter an occupation that completes or constructs design or installation. In this regard, the self-certification system requires occupational regulation so that a standard for entry is met by the individual practitioner. Self-certification systems and processes then focus on regulating the output provided by the relevant practitioner to allow them to certify their own work. While extending self-certification is still in its early days, this proposal aims to tackle New Zealand's bloated project delivery times, which the Minister for Building and Construction, Chris Pink, claims will support more affordable homes and a stronger economy. It is common ground within the building industry that the consenting process is disjointed, protracted, and in need of an overhaul. The current liability settings mean building consent authorities are faced with the possibility of footing the full repair costs for defective building works, despite only playing a small role in the overall life cycle of construction projects. Since the leaky building epidemic and the High Court's Spencer on Byron decision, councils and other building consent authorities have faced exposure to risks and costs disproportionate to their role in the consenting and certification process. There can be no disputing the fact that there is need for systemic change. However, the solution needs to balance these issues against considerations of the risk of poor build quality and lack of redress for owners of defective building works. The government's proposal is a part of a raft of policy changes to the construction industry. As you may have seen just yesterday, it was announced that the government will be doing away with the joint and several liability framework and implementing proportional liability. This marks the biggest shake-up to the building consent system since the Building Act came into force. According to Chris Pink, outdated systems have stalled progress and driven up costs, making it around 50% more expensive to build a standalone home here than in Australia. By shifting to proportionate liability, the hope is that the cost of burden on ratepayers and risk-averse behaviour from councils will be reduced. The government is also giving councils the option to consolidate the building consent authorities, which will hopefully eliminate inconsistent interpretations and reduce delays. The rationale behind self-certification is straightforward. Building practitioners presumed competent in their field are empowered to certify that their work complies with the prevailing statutory requirements regarding building design and construction, without the need to involve the local authority. For construction industry trades, a self-certification system would be prescribed by regulations and allows registered and licensed practitioners to sign off their work as meeting a stipulated standard, eliminating the requirement that all work be inspected by state authorities. Self-certification may be more difficult to implement in a performance-based system if there is room for alternative interpretations of what is required. Interpreting and implementing regulations therefore requires expertise and the ability to understand the relevance of the requirements to the context. This emphasises the importance of appropriate training and the definition of acceptable solutions. In New Zealand, the certification standard for building work is structured to ensure that all construction complies with the New Zealand Building Code, thereby safeguarding the safety, health, and well-being of building occupants. The process involves multiple stakeholders, including building consent authorities, professionals, and inspectors. Certification occurs where a building consent authority, an installer or designer, and an independent third-party inspector certifies that the drawings, specification, design work have been completed to the standing required by the building code. While these are modes of self-certification, certification is predominantly carried out by building consent authorities. Essentially, building consent authorities are the cornerstone of New Zealand's certification framework. They are responsible for issuing building consents, conducting inspections, and granting CCCs, or code compliance certificates. These authorities ensure that building work adheres to the building code and the specific conditions outlined in the building consent. When work doesn't meet the required standards, authorities have the ability to issue notices to fix non-conforming work. The CCC is a formal statement issued by an authority under the Building Act. It confirms that work carried out under a consent complies with the consent and the building code. The CCC processes involve a final inspection by an authority to ensure all work meets the required standard. It's mandatory to apply for a CCC upon completion of building work. New Zealand's current liability settings are complex and have been significantly influenced by the court's decisions that building consent authorities can owe a duty of care under the Building Act when issuing CCCs. The landmark case in New Zealand, Spencer and Byron, held that the council owed a duty of care to the property owners as it issued a CCC for a development with weather tightness issues. The decision went beyond previous case law, finding that a building consent authority can owe a duty of care to non-residential commercial owners. As one would expect, it had far-reaching consequences for the liability of BCAs and other stakeholders in the construction sector. A thorough understanding of these liability settings is essential when considering any extension of the self-certification framework in New Zealand. While both building consent authorities and building practitioners have considerable responsibilities in ensuring compliance with the building code, the principle of joint and several liability often results in councils disproportionately absorbing the costs of building defects. Under this principle, where multiple parties are responsible for a building defect, each party may be held liable for the full cost of remediation, regardless of their proportional responsibility. This has proven contentious as it frequently results in building consent authorities being required to cover the entire cost of defects when other liable parties, such as builders or developers, are insolvent or otherwise unable to contribute. Currently, self-certification in New Zealand is limited to electricians and gas fitters. These tradespeople can certify that their own work meets building codes, provided that they meet specific competency and experience requirements. This process is designed to streamline the approval process and ensures that qualified professionals can manage their work while maintaining safety and compliance standards. The proposed self-certification scheme would allow trusted building practitioners to certify their own work for low-risk projects, such as residential dwellings. Chris Pink says this initiative seeks to reduce delays and costs associated with the current building consent process while maintaining quality and accountability. Under the proposed changes, qualified tradespeople, such as licensed builders, would gain self-certification rights similar to those currently available to electricians and gas fitters. The proposal includes safeguards to ensure compliance and maintain consumer confidence in building work. For example, self-certification would be limited to specific low-risk projects, preventing use for high-risk or complex builds. Additionally, building practitioners who self-certify their work would be subject to stricter qualification requirements, oversight mechanisms, and accountability measures. A system for handling substandard work is also part of the proposal, ensuring that homeowners have a clear pathway for redress. Importantly, this scheme shifts some liability from councils to self-certifying practitioners, making them directly responsible for the quality and compliance of their work. In Australia, the various states operate under different forms of self-certification via a private certification system. These systems allow registered building certifiers to approve building work and issue compliance certificates without requiring council involvement. Each state and territory administers its own regulatory framework, with notable asymmetry, with some states deciding certain trades are too dangerous while others are safer. The primary objective of private certification in Australia is to streamline building approvals and reduce bureaucratic delays while ensuring regulatory compliance. However, concerns have been raised about conflicts of interest as private certifiers are often engaged directly by developers. For example, in New South Wales, there is a framework intended to enhance regulation of certifiers and impose stricter requirements to mitigate risks associated with self-certification, but this has led to criticism of being rushed too quickly. Critics of the self-certification framework have stated their belief that there is a conflict of interest where tradespeople provide their certificate to the building certifier. Linda of the Australian Building Management Board has said, "I would go back to the independent local authority mode for building certification. Yes, they are slow, but a quality job is not a rush job. We raced to the self-certification model too quickly. We were not mature enough." Australia's liability settings have been referred to as confusion approaching chaos due to the court's division over the inclusion of economic loss in the law of negligence. The approach taken in Australia is more restrictive than that taken in New Zealand. Attempts to establish a duty of care through common law have been rejected continuously, such as the High Court's unanimous overturn of the Court of Appeal's decision to establish a duty in Brookfield Multiplex. In New South Wales, the Design and Building Practitioners Act, or the DBP Act, has circumvented the need for debate before the courts by legislating that a blanket duty of care is owed by someone carrying out building work to each owner. Of course, there is a clear legal basis for this default setting, as uncertainty and resulting litigation has a net cost to society. The DBP Act undoes the court's prior position on concurrent liability, as a duty of care exists regardless of the underlying contract, and the ability to contract out of a duty of care is no longer available. Another case in Australia considered the DBP Act and established some key principles. Most relevantly, anyone who supervises construction work can owe a duty of care, regardless of whether they provided physical building services. It held that the purpose of the duty of care is to ensure reasonable care is taken by people carrying out any work entrusted to them. In practice, this means building consent authorities, including local authorities, can still be liable for breaching a duty of care, regardless of the transfer of responsibility to self-certifying practitioners. In the United Kingdom, there is a framework for certain qualified practitioners to self-certify without requiring local authority inspections. The system is governed by the Building Regulations Act and primarily functions through competent person schemes. Under these schemes, tradespeople such as electricians, gas engineers, and heating specialists can self-certify compliance, provided they are registered with an approved accreditation body. Examples of these bodies are the National Inspection Council for Electrical Installation Contracting and the Gas Safe Register. Self-certification in the UK is intended to improve efficiency. To uphold accountability, these accreditation bodies conduct periodic audits, and regulatory authorities retain the power to impose penalties for non-compliance. Despite these safeguards, there have been concerns about inconsistent enforcement and the risk of non-compliant work passing through the system. In response, regulators have sought to strengthen auditing processes and impose stricter requirements on self-certifying professionals to ensure adherence to safety and quality standards. The United Kingdom's common law position bars any claim for economic loss from being brought against local authorities. The decision in Murphy and Brentwood District Council restored the position that recovery is not available for economic loss unless a special relationship could be established under Hadley-Byrne. Lord Keith held that the previous interpretations of the two-stage approach in ANZ was not appropriate. This approach, which remains law in New Zealand, asked whether there was a sufficient relationship of proximity between the wrongdoer and the sufferer, and if yes, whether there was a reason to exclude liability. In Murphy and Brentwood, it was held that ANZ could not be recognised for having a basis of principle, but was a remarkable example of judicial lawmaking. Balancing the UK's exclusion of council liability is the requirement that all building practitioners hold latent defects insurance. This type of insurance covers defects in construction projects and protects the owners from costs arising from remedying defects arising from workmanship, design, and material issues. It acts as an alternative to council liability as it protects property owners from financial losses due to defects arising after the completion of a development. While the bureaucratic hurdles are designed to protect consumers, there is an argument that they are undermining innovation in New Zealand. This can be seen within the consenting process. Consenting timeframes remain slow and beyond any practical expectation of owners and purchasers. There are definitely major economic impacts in commercial developments, such as delayed cash flow and solvency issues. Removing responsibility from the hands of building consent authorities will hopefully remove the susceptibilities of councils and thus ratepayers of footing the bill of repair costs that they did not have a major role in. Of course, the necessary caveat here is that the courts or government would have to determine that councils no longer hold a duty of care, which is being implemented now. Self-certification does not necessarily imply that the councils will no longer owe a duty of care, as the framework has to be implemented by the government. Councils have also reported long wait times due to being understaffed. As training compliance officers can take a significant amount of time, it would be beneficial to remove this burden from the councils. From a logical view, it would make sense that a building practitioner is adequately qualified to assess the workmanship of specific building items. Self-certification might lead to better quality work, as building practitioners will actively need to assess their own work through a regulated framework. The process of measuring building work against a standard of workmanship could mean that the practitioners exercise increased levels of care. In terms of risks and suggestions, the main reason against moving towards self-certification is the fear that the private sector will be incentivized to cut corners and self-certify without properly ensuring compliance with the building code. If too much power winds up in the hands of building practitioners, there is a fear that they may end up taking the role of the judge, jury, and executioner. To minimize this possibility, there are input and output controls which can be utilized. From an input perspective, the barrier to entry should remain high, following the current framework overseas, and in New Zealand, whereby only certified gas fitters and electricians can self-certify. It's crucial that the appropriate standards are required to be met, and a regimented testing framework to decide which building practitioners can become self-certifiers, such as in the United Kingdom. From an output perspective, building consent authorities should continue to have a level of oversight and conduct randomized checks of certificates of completion. In instances where compliance is deemed not to have been met, penalties against the building practitioner should be imposed, and they should be stripped of their self-certification ability, depending on the nature and consistency of their breaches. This will have a commercial deterrent effect, as self-certifiers will want to retain their ability to self-certify from both a project management perspective and for their market reputation. There is a risk that subsidiary companies will wind up on project completion, escaping liability for defective building works. A solution to this could be requiring third-party guarantees from related companies, as defined in the Companies Act, or an alternative guarantor. Of course, there are other methods of security, such as bonds and retention sums. However, in the construction market of New Zealand, it's unlikely that subcontractors and contractors would agree to such onerous obligations without government input. While the United Kingdom's LDI framework could provide a safety net for defective self-certified building works, there is a question of whether New Zealand's insurance market will be able to adapt to this. Ideally, New Zealand could introduce an LDI regime and move latent defect risk to the insurers, rather than building consent authorities footing the bill for poor building design work. The banks would also need to treat LDIs as a condition of funding purchases, as they do in the United Kingdom. Building practitioners should also be required to take out professional indemnity insurance. However, if responsibility for self-certification falls to building practitioners, the market will have to respond accordingly, with consumers facing the cost increase. Depending on how the government elects to fund the self-certification program, there is a risk that small businesses will be priced out of the market. It's recommended that any continued professional development costs are provided freely to self-certifiers. However, it is noted that there is a clear economic incentive for businesses to join in the long run, as consumers may be more likely to go with a quicker option. The proposal to extend self-certification abilities to trusted building practitioners represents a significant shift in New Zealand's construction landscape. The initiative aims to streamline the project delivery phase. However, the success hinges on a careful balance between innovation and quality control. Hopefully, my legal analysis has highlighted some benefits, including improved innovation, reduced council liability, and better quality workmanship. By reducing bureaucratic hurdles and placing more responsibility on the building practitioners themselves, the industry could see a boost in efficiency and accountability. However, the risk associated with self-certification, such as quality control issues and the potential for increased insurance costs, must be acknowledged. Ensuring that building practitioners are adequately certified and subject to regular inspections will be crucial in maintaining standards and protecting consumers. New Zealand's insurance market will need to adapt, with latent defects insurance becoming a component of risk management. Small businesses may face challenges in meeting the new requirements, but with appropriate support and incentives, they can also benefit from the streamlined processes and increased opportunities. While the introduction of self-certification in New Zealand's construction industry presents both opportunities and challenges, I think with the right frameworks, it does have the potential to transform the consenting process and ensure efficiency. Okay, thanks for your time, everyone. Please feel free to ask.
I want to assume, okay, and how a clicker works. Right, this is me. I'm Oscar. Thank you for the introduction. That was lovely. I did not know where that blurb was going about myself, so that's fun. We've got a little agenda for tonight, and to be frank, I'll probably go off script, depending on how we feel. But the kind of key points that I want to get across today is 3910, we've got 2013, 2023, and the approaches to arbitration, and particularly the way that the dispute resolution mechanism is structured has changed quite dramatically, and for the first time in many, many years. The 2013 approach, as we'll see, and I'm sure as many of you know, has been the industry norm for, I don't even know, 20, 30, 40 years, if not more. Then we're going to look at this very niche legal point, that being admissibility versus jurisdiction. That's what caught my interest, being kind of a legal academic nerd, but hopefully by kind of understanding what this distinction could be, for you it might get you thinking about how you might use preconditions to arbitration, how you might structure dispute resolution clauses in your contracts, and how you might think about compliance. Lastly, we're going to look at practical application. So that's twofold. One, how the courts have dealt with this previously. And then secondly, how you might make tweaks to the approach in 3910 or in any other contract. And that's where I've brought in this hybrid clause, not necessarily as the best way forward, but as an example of how you might make changes to your contracts and the way that you structure your dispute resolution mechanism. The next slide here goes straight into what a precondition is, but I think I might take a step back first and just think about what exactly the purpose of this is. It's not an academic lesson in jurisdiction and admissibility, as much as I'd love to talk about that. It probably interests me more than you. What this is an invitation to consider how we structure disputes. And as people involved in the construction industry, we know that disputes are everywhere. It's actually a part of the process. It's not this kind of taboo thing that happens at the end. It's a way that we fix the price, that we determine the due date for completion. And so we need to be thinking about how we want those disputes to run at the start of the project, when we're negotiating the contract and when we're negotiating the dispute resolution clause. That's when we need to be thinking about it. And one of the things that really got to me, and one of the cases I'd worked on, is the dispute resolution clause is negotiated here in year X, but it's used here 5, 10 years later on complex projects. And so we need to be thinking forward about how the project may be going. And usually when the transactional lawyers are pulling these deals together, everything's optimistic and happy, but sometimes it doesn't end up that way when it comes to the back end with disputes. And so just taking a pause to think, if that happens, if things do deteriorate, is the process we've agreed going to be right for us, or is it not? And that's going to be bespoke. It's going to be between the parties, the type of project, and the contract itself. So that's what I'm hoping for. Thinking about how we structure disputes, which is probably not a subject we like to be talking about at the start of a project. So what is a precondition to arbitration? If we know 3910, it's in section 13. It's what we must or may do before we get to arbitration. And I've got a little diagram on the next slide, which kind of sets out the 2013 and 2023 approaches. But one thing that's important to understand when structuring these things is whether it's a mandatory precondition, something you must do before you move to arbitration, or something you've kind of included in the contract to guide the parties when they might not be thinking about the relationship anymore, when the relationship's broken down. How do we want this to proceed? All things, being the best that they can be. And that's when we might use kind of words like may. The parties may negotiate, maybe in good faith, or the parties may go to mediation. Of course, they always can. You can always agree to a process, but it's better to kind of put that in when all the parties are happy and optimistic than, when something's hit the fan, and I don't know if I'm allowed to say what. So that's what they are. The other thing to note is there's 3 preconditions inherent in any arbitration agreement. So when you say you have an arbitration agreement with no preconditions, yes, but there are 3 inherent. That's an agreement to arbitrate. Makes sense. But one of the cases we'll look at in the practical section, that was the question for the court. Is there an agreement to arbitrate? Next, is the dispute capable of resolution? So that's the arbitrality of the dispute. Is it contrary to public policy? And it's also, is there a dispute? That's another issue that comes up before the courts. Are the parties actually in disagreement? Maybe, maybe not. And then a compliant referral to arbitration. And this is kind of the key one that comes up in the cases we're going to look at. I kind of went into a spiral as I was preparing for this because I thought I'd kind of got it all wrong. But we'll get there. I think we're right. The first 2 kind of do go to jurisdiction, which we will get to. So if there's no agreement to arbitrate, clearly any tribunal does not have jurisdiction. And if there's no dispute or it's not capable of arbitration, no jurisdiction. But that third point, and this is why I spiraled, borderlines on jurisdiction and admissibility. So when we get there, I'll talk about that. Cool. So I'm sure most of you in the room will be familiar with 3910. I see a photo being taken. These are not entirely correct, so please do not rely on them. They're indicative only. There should be far more arrows and lines, at least in the 2013. But the basic point is 2013, there are steps. You go to the engineer's review, you get a formal review, maybe you go to mediation, maybe you can't agree a mediator, maybe you don't agree at mediation, maybe you dispute the mediator's binding recommendation, but you have to do these things before arbitration. They're mandatory. So certainly the engineer's formal decision is going to be a key precondition to arbitration, and it's mandatory. But and so that's been the industry standard, as you will, for the last kind of 40 odd years. Now in 2023, we have a new approach, and that's basically you have options to resolve your disputes. Engineers, review, adjudication, mediation, they're at your disposal, but by and large, you can proceed straight to arbitration. I've put in this little caveat with negotiation. This was raised, I think, last year at one of the SCL meets, whether the wording of 2023 is mandatory or optional. I've put the clause there. It does say will, which would tend to indicate that it's mandatory, but the guidance at the back says that it's optional. I'm going to flag that as a little kind of practical reminder that the wording of these clauses is going to be pivotal when it comes to disputes, because you might, I don't want to be cynical, but you might agree at the time when the deal is entered into, it's mandatory and optional. But when you're in dispute 5 years later, that's what your litigators are going to be picking up, saying, whoa, we haven't negotiated in good faith, or any other kind of word in there. So making sure that the dispute resolution clause is crystal clear from the outset as to how exactly you want those disputes to proceed. And just again, stepping back, I don't have a view on which is better or worse. And I think the answer is it depends on the project. And so that's what I really think this industry needs to be thinking of, is when we're entering into these contracts, which is better? Is this going to be the kind of relationship where if we escalate it slowly, maybe we will reach agreement or at least clarity? And then perhaps a multi-tiered resolution clause like in 2013 is better. Or, are we really at arm's length and the relationship doesn't matter and we can just wait till the end and put it to arbitration? So now we get to the kind of technical legal point, and this is that I say it's a developing distinction in international jurisprudence. It's been flying about for kind of 15 odd years, so developing's relative. The short point is our big trading partners seem to agree that there's a distinction between jurisdiction and admissibility, and I'll get there, but it hasn't reached New Zealand courts as an issue for determination yet, so jury's still out on whether we will follow it. And it is an important point. In New Zealand, we follow the International Arbitration Act. Our Arbitration Act 1996 is based on an international standard, and so we tend to follow international jurisprudence. So when this does come to the courts, it will be interesting. The bigger point is, what is this distinction? And I think the UK High Court kind of summed it up better than I can, so I won't try and do it better. And it's that quote there, issues of jurisdiction go to the existence or otherwise of the tribunal's power. So that's their jurisdiction to determine the matter. Issues of admissibility go to whether the tribunal will exercise that power nonetheless. I'll get into the kind of 3 reasons why this matters. But really the first question is, who did the parties intend to determine this dispute? Is that the court or the arbitral tribunal? That's essentially jurisdiction. And then admissibility is, what did the parties intend to happen before this dispute got there? And that's admissibility. So why does this distinction matter? And I've kind of broken this down into 3 key points. There's probably more, but I think this will do. Internal coherence. This one's quite hard to articulate, and so I'll pose the opposite. If you have an arbitration clause, the preconditions are not met. If preconditions to arbitration go to the tribunal's jurisdiction, before they're satisfied, who has jurisdiction over dispute? The answer you have in your head is, well, it's the tribunal, you have an arbitration agreement. But the logical conclusion from that statement is, well, it has to be the court, because if there's preconditions, they're mandatory and they're not met, and they go to jurisdiction, then there's no jurisdiction. So if that can't be the case, then it's something else. What is it? It's admissibility. It's another word. So internal coherence, that really excites me, probably doesn't excite you, so we'll kind of move promptly on. Limited judicial intervention. This one's really important. In Schedule 1 of the Arbitration Act, you have 2 key clauses, articles rather. 8. Article 8 allows a party to apply to the court for a stay of proceedings if proceedings are brought when the dispute should be referred to the tribunal. Now, this begs the question of who has jurisdiction, right? And one of the cases we'll look at quite shortly, that's how the challenge was brought. It was a application for a stay of proceedings. If the issue between the parties is compliance with admissibility, that would lead to a different outcome than if it was jurisdiction. So in one of the later cases, we'll see the party argued, well, they haven't negotiated in good faith, therefore you can't grant a stay. And the court said, well, no, there's an arbitration agreement, this dispute falls under it, so I'm granting a stay. And the second point is Article 16. The court can determine a tribunal's jurisdiction. Right. So if these matters, compliance with preconditions, are matters of jurisdiction, the court can determine them. You can go to the court and say, we've not complied with the precondition, the tribunal doesn't have jurisdiction. The matters of admissibility, you can't take it to the court. It's a matter solely for the tribunal. And then this comes into play in Articles 36, which is opposing enforcement of an arbitral award. So one of the grounds that you can oppose enforcement is that it was made outside, the tribunal acted outside of its jurisdiction. Preconditions are a matter of jurisdiction. That could be a grounds for refusing enforcement. If they're not, then the court can't review that. And it's the same with Clause 2 of Schedule 5, appeals and questions of law, one of which can be as to jurisdiction. Cool. So that's judicial intervention. By making this separation, the courts have less ability to determine matters that are properly for the determination of the tribunal. And if you're a supporter of arbitration or alternative dispute resolution, then giving the maximum power to the tribunal is possibly, I won't speak for you, something that you support. Or at least it's in line with the purposes of the Arbitration Act, which is to limit the court's intervention. The last one, procedural flexibility. This one just kind of ties in with the preceding two. What can you do when a precondition is not met? It doesn't make sense to have interim relief granted where there's no jurisdiction. It doesn't make sense to me. Then again, our now Chief Justice did order it, and I hope she doesn't hear this. One of the cases is her decision back when she was a judge of the High Court. I think she she essentially said that jurisdiction was waived. I don't quite understand how that works. That made sense as the law was then, but I think it's much easier to have that procedural flexibility to stay proceedings while preconditions are satisfied, or waive the need to satisfy a precondition because they go to admissibility rather than jurisdiction. That's that point. Cool. So these are the three cases I've been alluding to. I think the Chief Justice did Downer Construction when she was a judge of the High Court. I won't get too far into the details of these cases. The facts are probably more complex than they need to be to illustrate the point. In Downer, the issue was basically, these are Downer and Unrich are both under 3910 as a frame of reference. The issue in Downer was whether certain counterclaims had been subject to an engineer's formal decision. So in that case, the engineer, one of the issues was a payment claim issue. The engineer had made certain deductions for the repair of defects that hadn't yet proceeded or been carried out by another contractor. The engineer certified those deductions and certified a negative payment schedule that was challenged by Downer. And the underlying reason was that Downer said that's not how the clauses worked. So that was kind of that dispute. And the second dispute was, this is a Leaky Holmes case. So the question was, there was an instruction from the engineer to Downer to rectify the defects. And Downer said, well, that's going to require a variation at cost. And so the engineer said, no, you've not built this properly. There will be no cost to the principal. And that went to formal decision. So when Downer took those two issues to arbitration, the referral referred the two engineers' decisions. But the scope of the decision was more than what's on the paper. It necessarily included what was the cause of the defect and was Downer in breach by the way they had constructed the building. So those kind of, the arguments underlying the formal decision were bigger than the formal decision itself. And so the question was, well, if you have a counterclaim that's in the realm of those disputes, but not specifically subject to an engineer's formal decision, have you complied with the precondition that every dispute must be subject to an engineer's final decision? And the court said, basically, Downer, you've made the dispute more than the black letter of the decision. So you're stopped, or you've waived your right to require compliance with that precondition. And it makes perfect sense if it's admissibility. You've basically, by conduct, said, I accept that this dispute's going through. Unrich basically follows Downer. It's another example, so I don't need to stress the point here. The procedural, prelude to it's a bit convoluted. It's an application for leave to direct a liquidator to bring defences or counterclaims in a very complex set of proceedings. But the basic point was the court looked at whether, when deciding whether to grant leave to make those orders, the court looked at whether the defences had a basis. And the court's position was, well, the plaintiff has brought all of these claims, most of which haven't complied with the preconditions to arbitration. And so we don't see any need to defend them because there's no jurisdiction. And so that was a straightforward application of Downer. Again, ruling makes perfect sense, but better explained in terms of admissibility. Last one, Acanthus and Watercare. This came out at exactly about the time this article essay was submitted, so it remains a very topical problem. The case is the bigger issue in the case is whether there was an arbitration agreement. It was in the context of about 5 different contracts that governed the parties' relationship, only one of which contained an arbitration clause. So that was the key issue. But a sub-issue for the court was, in that arbitration agreement, there was a precondition that the parties engage in good faith negotiations, and failing that they attempt to mediate. And so this is what Williams and Kawharu called the courtesy trap. You put in what you think is a courteous, good thing to do, and you require negotiation, and you require mediation. And this, well, at least successfully delayed any proceedings. And this was the case that was the application for a stay, just to tie in all my random points from before. The short point of this is, 1, the distinction is still relevant, and 2, another warning of mandatory preconditions. Sometimes they can really they can bring an early resolution, and sometimes they can create more problems later. In this case, they caused more problems later, and the court had to go through the parties' entire kind of years of working through the disputes to figure they had in fact been complied with. So that's the application. Pros and cons, I think this has been implicitly covered. But essentially, when you have a multi-tiered dispute resolution clause, the issues get aired. Hopefully they get resolved at less expensive, less involved processes, or at least if they go up to arbitration, you're pretty clear on what the other party's trying to say. That's the idea. A good one in the construction industry as well is, if you have to make a claim to the engineer, at least both sides have a kind of good idea on what things are costing at the time. On the other side, if you can go straight to arbitration, there's more flexibility. You can, prioritize the project and the relationship and leave the kind of nasty fighting to the end. But there's little insight as to what claims each party might have, and therefore what things are costing and what delays might be on foot. So the hybrid clause. This is where my thinking led me to. I saw pros and cons on both sides. I saw, when the parties are working well together at the outset of the project, a multi-tiered dispute resolution clause like that in 3910/2013 can have great benefits. You bring claims early, you can resolve them hopefully before it gets too litigious, you get price certainty, and hopefully your dispute resolution's cheaper. But as the project goes on, and potentially as the relationship between the parties deteriorates, that can get in the way. And parties can bring more and more claims, or the fact of putting your personnel aside detracts from what's best for the project. And in such situations, it might be better for the parties in the project itself if you could waive those preconditions and leave anything to come to the end. And that's kind of what I've tried to do. I'm a back-end lawyer, I'm not a drafter, but this is my best attempt at putting that into paper. It basically says, look, an engineer's final decision's a precondition. You've got to do it in a time frame. But if there gets to a point where either party wants to stop that from being a precondition to arbitration, you can serve a notice and both parties agree that it'll be waived. The pros of this, you get that early resolution at the start of the project. You have some insight into what costs and delays might be coming. Hopefully you're resolving disputes and not breaking down relationships, and you're saving those costs in that process. But if you need that flexibility, it's there. The cons for that notice, like giving of the notice, that's a litigator's dream. Was it validly given? Was that dispute known when the notice was given? You're going to have a fight unless it's done well. So that's a risk and would need to be managed really well. And then, yeah, it just adds complexity. And when disputes get bad, that complexity can draw things out. Great. I've taken up enough time. I hope that made sense and got you thinking. I'm going to hand it back. Perfect. Hey.
So could both speakers please pop up and we'll take questions.
No pressure.
Oh, come on.
Thoughts, feelings, opinions, or stories? Key takeaways?
Question for you on the Oscar, on the wording of the clause and the debate, the tension between the will endeavour, the will bit and the wording, and the endeavour bit, the sort of aspirational element that's emphasised in the guidelines. Aren't there two potential, I think we would call them weasel words in there in the process? One's the will, where the will means shall, must, or will is kind of, yeah, maybe. And the other one's the endeavour aspect. So you can manufacture an effort at a good faith negotiation that you be not entering into in good faith at all, but have a sort of a paper process where your endeavour is coming down the red carpet in Alaska, but you've got no intention of actually having a meaningful conversation. So to make it mandatory in your research, do you think that the wording needs to be really emphatic to compel parties to comply with the process rather than have a sort of a halfway house?
Yeah, I think, you're going to run into issues with will, with endeavour, and endeavour in good faith. There's three arguments you can have there, whether it's mandatory, whether you've tried it all, whether you've tried in good faith, or whether it was, kind of a showcase. There's going to be three issues. But the step back is at law, an agreement to agree is not enforceable unless there's something there for the courts to enforce. And I'm not entirely convinced that it's sufficiently clear what exactly the parties have to do to try and agree for a court to enforce it. It probably would, because it's 3910 and used widely in the industry. That's a bit of a practical aspect, but I think for it to be an enforceable precondition, you would really need, the parties will try within 10 days or 20 days to reach agreement and kind of build that out on what exactly the attempt, the endeavour to agree in good faith looks like for it to be enforced.
Questions? Come on, peeps, I bought you time. Excellent.
So in regards to the arbitration, if you were going to try and do something else there quickly, why would you not use the adjudication process under the CCA?
The adjudication's a very good tool, and especially if you want things done quickly. I think if you wanted something done quickly, you probably would. If the dispute was appropriate for adjudication, we get very complex disputes through adjudication, but sometimes, maybe they shouldn't be. But I think the thing there is when you have a really complex dispute or a really contentious dispute, adjudication's the interim decision, and that's what it's intended to be. And hopefully the parties, it's a decision they can live with. But if it's not, then you will be probably progressing through to arbitration. But definitely, if you take the 2023 contract and you can have arbitration at the end, and there's disputes in the interim, adjudication is probably a perfect tool to have between the two.
Arbitration might come towards the end. It's ongoing disputes.
Or the engineer's decision as well. They do a great job.
Depends on the relationship with the engineers. Do you think it's going to suit that level?
Yeah. And hopefully we see, I don't know if trust is the right word, but more trust in that process at the end of the project, when it's the independent certifier. It's kind of a bit more of a wholly independent person.
Rico, what does the pre-qualification look like for self-certified builders in the scheme?
Yeah, I think that's a question of what standard you have to meet first, right, to be allowed to self-certify. And I think looking at the UK's framework, that was definitely a guiding light in terms of having practice area bodies that would govern whether practitioners can self-certify, and having a condensed, codified level of practice that you'd have to meet. Yeah.
When you researched that about the licensed practitioners, did you consider whether, with the requirement for insurance, whether it might be individual license or a collective or company license that might be more suitable self-certification?
Do you mean in terms of the individual, like the...
In achieving insurance, for example, if insurance is a precondition of self-certification, then an individual might struggle to get that insurance, might not meet the criteria that the insurance company might want. So you look at other jurisdictions, for example, in the UK, whether that was an individual that was licensed or it was a company.
I was coming to it from the perspective of a company being responsible for insurance obligations. I didn't look into any individual obligations. No.
There's much detail given around how it's going to work in practice from top of the relations development. So, they're going to see photos, are there going to be, recorded videos, or what's the, how they, is there any detail around the practicalities of the certification?
I don't think there's a workable framework at the moment, but there is remote building inspections as well. It's one of the policy suggestions. Yeah, I'm not too sure.
Councils probably won't want the photos, will they?
It's put out in the public before the actual legislation is passed, so it's intent, but not in detail.
Yeah, seems quite low on more details about it. It's just a-
Not your fault.
Well, we had that with the freeing up of the imported building materials restrictions, and the suggestion by the minister at the breakfast that the society arranged at the Beehive last year was that the idea was the councils wouldn't be liable if they led through something that was on the list if they hadn't tested it themselves, because it was permitted by the government. And then people said, well, okay, so if it fails, so if you have a product that fails across the country, aluminium coated panels, just to pick something completely random, who's going to pick up the tab? And he said, the government would. It's like, oh boy, you might want to go and talk to your Minister of Finance before you offer that. I don't think it's been repeated, but that was the thinking.
We decided tonight it's good if you have a new picture of the details.
You announce it with conviction.
The breakfast.
Yeah.
Have you presented your stake to the minister? Have you submitted it to him?
No, I haven't.
Yeah.
Because you raised some good questions.
Yeah.
And they're looking at it right now. There'll be policy people working on doing exactly the question that you raised, which is that's a good speech, Minister. Now, what do we do?
If they ask them how they can insure it.
Yeah.
Give them insurance. The ability to get insurance is already limited in New Zealand at the same economies of scale of the UK. And I suppose you can argue that you can self-insure. You know, who pays for that being really, because the cost is going to be passed on. So it is a worry.
And if it's tied to companies, and it's relatively easily done to just simply wind up your company and move on to another vehicle with no sanction, then and I think that's something that you did raise in your paper, which I thought was very good, that there are limitations to that, because you can just easily, if you finish a bunch of work and you think there might be a few issues, you drop that one and pick up a new co and away you go. And in theory, we don't like Phoenix companies, but they happen all the time. I don't think there's any particular enthusiasm to enforce the restrictions.
So I understand that we have electrical self-certification, yes.
Mhm.
Is the reason that if they're already quite heavily regulated, then much more risky? And if that's the case, do you know what kind of other trades, like in Australia, have got self-certification?
I should. It was definitely covered in my essay, but yeah, from memory, it was a range, but it varies from state to state. Yeah. My essay will be online though.
The assessment of whether that approach works or not, and the reasons why it works or not, is fundamental if you're going to transplant that approach onto buildings in general. Right? So, if that supporting kind of like context and frameworks are in place, you can't expect the same approach to work necessarily.
I think it comes down to what you were saying, Rich, about what's the evidence really acceptable, whether it's photographic or videos and everything else. And as I think the Minister was looking, as the proposal was looking at regulating that aspect of it as well, sort of regulating what evidence is acceptable. And if you can enable it to be submitted remotely, it means that it could be submitted not to your local authorities, but it could be like a central consenting authority that would look at it and then cut down on waiting lists across the board, rather than, we have bigger waiting lists in some areas than others, whereas this might be a mechanism to even this playing field. But I think in doing that, they were looking at very tightly, considering what sorts of evidence would be acceptable and regulating that so that it's consistent. Yeah. Be interesting to do with the proposals now, probably.
And some of those things are only achievable if they go to a centralised system, because some local territorial authorities can't afford the cost of creating that infrastructure that would afford those documents.
So some don't have an electronic document management system, even just a basic one.
There's a whole lot of things all happening potentially at the same time.
Yeah, and bring out the training as well, to actually enable the practitioners to be able to do them.
Yeah, all that combined, plus the insurance requirements, plus all of that, you obviously tipping the scale very much to larger companies. New Zealand's market and the sort of buildings they're talking about, single residential, single builds, they're predominantly small companies around the place. And does your essay look into whether this is really just going to force a lot of small companies up to these bigger umbrellas?
Yeah, I definitely think that there's a risk that it'll price out small companies from the market. Yeah, I think that the government would have to put some sort of support in place for small companies to be allowed to compete against larger ones.
I think that'll happen by natural attrition rather than intent, because those companies will be able to put insurance, they have quality assurance programs, and I think all the smaller builders do subcontractors to those bigger ones who take the risk. So going forward, it's interesting from a licensed building practitioner perspective. The ones that want self-certification, the ones that feel they do a good job, it looks like it's going to turn more towards the bigger companies with their volume rather than the individual good builders, because they have a quality assurance scheme that can ensure that their product meets a certain standard. Probably, possibly where it's going to lie, but we'll wait and see how it falls out.
And if they put up 24 houses with no gaps and no waterproof membrane, it's a big problem.
You might need some sort of cooperatives for those smaller guys to get together. And
Yeah, as long as it's not a cartel. Police commission will be after them. Righty, I think that's us. Thank you all for coming here, but especially thank you to our amazing presenters who now go off to further adventures in Wellington and Auckland. Yes, I do now remember. But I think I went to university there. And really looking forward to the reception that your essays get when they're presented in those places. But thank you again for coming out here, and for those of you for joining us this evening, and for those of you online stuck with the live stream. So it's fantastic. Thanks very much, everyone. Just if you want to get